Great. Welcome, everyone, to today's regularly scheduled meeting of the Blue Ribbon Commission on the future of the California bar exam. We are going to begin by taking roll. Devin.
Susan Bokshian.
Present.
David Boyd. Alex Chan.
Present.
Charles Dugan.
Present.
Jeremy Evans. Jackie Gardina. Ryan Harrison.
Present.
Dr. Henderson.
Present.
Esther Lynn. Tracy Montez.
Here.
Judge Reeser.
Present.
Natalie Rodriguez.
Here.
Kristen Rossi.
Here.
Emily Scavoletto.
Here.
Karen Silverman.
Here.
Mylan Spencer. Amy Williams.
Present.
Joshua Pertula.
Here.
We have a quorum.
Great, thank you, Devin. Let me begin with just very brief chair's remarks. We have, I believe, a little bit of a lighter load, and I say that in time, not in substance today. We are going to begin with out-of-state law school applicants, out-of-state attorneys, and foreign educated applicants, and how they will be treated, and recommendations we might make that will change the current status quo, if at all. We will have a potentially a brief discussion on the non-exam pathway to the extent that anyone has additional comments that weren't covered before, but I don't expect that to be a long conversation. We spent a lot of time on that. And then we'll get to finalization of the exam pathway, and ultimately to some direction to the staff and to a board report that we are going to put out, or a commission report rather, that we are going to put out. With that, I'd like to start with public comment. To the extent that there's members of the public who would like to make comment, please raise your hand and Devin will call on you. Thank you to those that have submitted written public comment. That has been circulated to all of the commission members. With that, Devin, let's go ahead and start public comment.
Our first public comment is going to be from Ray.
Thank you. Good morning. Ray Hayden here, and I hope everyone can hear me okay. I'll be reading a prepared statement to keep it short, and I presume that everyone has my notes for this meeting. This is additional information. The IAALS, IELTS, and the NCBE have both determined that the current bar exam is invalid. Specifically, both entities have determined that the MBE portion of the exam is invalid on its own. In fact, the NCBE is not even including the MBE on the next gen bar exam. The written portion of the bar exam is scaled to the MBE in jurisdictions where the MBE is used as part of the bar exam, and the MBE has been in effect since February of 1972. Based on the information that I can find through many of the sources who have briefed the Blue Ribbon Commission on these subjects and additional resources, based on the above information, please do fact check me on this. There is not a single attorney in any jurisdiction who's ever passed an MBE-based valid bar exam since February of 1972, based on the invalid MBE. This section is additional information, and it's going to be very short. The ABA was created in 1878 to control the profession of law. The AALS was invented in 1900, but festered into a position of authority within the ABA section on legal education. And the AALS is the reason why we study law in the ignorant fashion that we do to this day. Of note, the ABA never liked the way we study law. The NCBE was created by the ABA at the height of the Great Depression in 1931 to specifically control the licensing exam.
You have 30 seconds remaining.
Thank you. Old time language. The LSAC, LSAC, which does the LSAT, was invented in 1947, and their purpose is to collect all of our personal information in one location prior to even being able to study law. All right. Lastly, I would hope for a lot better from the BRC so far. I'm pretty impressed with the group of people that put things together, but you know, in the final say so of the whole thing, if you can't get it together on the non-exam pathway, the Supreme Court can still do what they need to do. Thank you very much and have a great day.
Next public comment is from Carolyn.
Good morning, and thank you for letting me have this opportunity to give public comment. My name is Carolyn Shining. I am a member of the former California State Bar State Working Group on paraprofessionals. We recommended a program. Unfortunately, that program was rejected and deemed to not be something that the State Bar would apply. In addition, the sandbox, I guess, has been put on hold pending state legislation. I was one of the sole dissenters to that project. One of the reasons that I based my dissent was that it would create a two-tier system of justice where people of California who in various areas do need additional legal support and legal access to affordable legal services would instead be provided with people who were not necessarily as competent or face the minimum competence that California has long recognized and has been the highest and of the highest standards in the nation. I believe that the proposals that you are suggesting at this point in the way they are suggested with regard to non-bar exam create a dangerous risk, not just to the members of, not just to the consumers of California, but to the very people that you seek to have become licensed attorneys. Not being able to understand the various interplay
30 seconds.
between all of the areas of law in California makes those persons subject to discipline in ways that they don't even understand. So I know it's hard to stand against the feeling like you need to produce something but something, as we said in the paraprofessional group over and over again, something is not better than nothing. So again, I believe that the results and the votes from previous meetings were correct, and I hope that you continue and perhaps do additional study on non-exam pathways before you move forward at this time. Thank you for the opportunity again.
Our next public comment is from Rianne.
Hi, my name is Rianne Pacheco, and I'm with the Legal Aid Association of California. Thank you for the opportunity to speak today. I have been monitoring this committee since its inception and have kept the legal aid community updated with your every step. I would like to voice my opinion on behalf of the legal aid community, who are on the front lines of the challenges presented by the current attorney licensing model. We are deeply concerned and disappointed in this committee's recent decision-making and the lack of legal aid representation in this committee overall. We have offered you our advice and expertise on multiple occasions without invitation, but it is being ignored. The chair has often explained to this committee that an alternative pathway recommendation does not mean the immediate approval of a non-exam licensure, and that it would just be a step in the right direction. A non-exam pathway to licensure is not the easier route, nor does it pose a threat to the public as it has been established. Yet many of you are refusing to vote for this and are not allowing California to modernize, setting us behind many states when we should be pioneering. We ask you to allow California to merely explore the non-exam pathway, to listen to the dozens of experts who have come to this committee to demonstrate the success and need for a non-exam pathway, and not let a year's worth of work go to waste. Thank you. I yield the rest of my time to Claire Solot.
Our next public comment is from Jennifer.
Can you verify the last name?
Jennifer Fair.
Okay, I'm actually I have a first speaker.
Sorry, what was that?
I have somebody speaking before me,
Okay, and who is that?
Lucas.
Okay. Lucas, you have 2 minutes.
Thank you, Devin. My name is Lucas Wright, and I'm with the Legal Services Funders Network. As you are aware, in 2021, the California Supreme Court asked the State Bar of California to form a Blue Ribbon Commission, known as the BRC, to explore the future of the bar exam. The BRC was charged with developing recommendations concerning whether and what changes to make to the California bar exam, and whether to adopt alternative and additional testing or tools to ensure minimum competence to practice law. Among the members of the BRC are 3 representatives from the California Lawyers Lawyers Association, known as the CLA. Ona Desomu, the former CEO of the CLA, was one of the original members. Ona was a perfect fit for the BRC, as she was not only a senior staff at CLA, she also spent 17 years at the Brookings Institution, a nonprofit whose mission is to conduct in-depth research that leads to new ideas and solving problems facing societies at local, national, and global levels. When she moved to the East Coast to pursue a new job, Jeremy Evans, the president of the CLA, took her seat. Mr. Evans is a sports and entertainment lawyer, and he operates a small private practice. He has made it clear that he is staunchly opposed to an alternative method for licensure. His position has not wavered despite the numerous experts who have presented to the BRC about the success of alternative licensure methods in other jurisdictions, the irremediable culture and physical biases associated with the multi-day closed book exam administered only twice a year, and robust public comment confirming that the California Provisionally Licensed Lawyer Program has been a great training experience for new attorneys, increases access to justice, and has not resulted in any disciplinary issues.
30 seconds.
Thank you. Despite being a member of the BRC, Mr. Evans co-authored an October 11th, 2022 public comment letter. In this letter are many false claims about the BRC and misleading comments about the findings of many presenters. Mr. Evans appears to be using his position to bias his audience against an alternative pathway to licensure. My colleagues will now explain the false and misleading statements made, and I yield the remainder of my time to my colleagues. Thank you.
Next public comment is from Jennifer Fair.
My apologies. Okay, so the first statement that I'm going to address is the alternative pathway being considered would essentially be non-exam and would eliminate any form of objective testing. So there's actually no facts that support this statement. The BRC has yet to make any formal recommendations and has never suggested that an alternative pathway must be exam-free. In fact, most recent BRC meeting, at that meeting, October 12th, a motion was made that specifically included an exam component as part of an alternative pathway. Mr. Evans actually voted against that motion. During the past 2 years of meetings, several presenters shared details about the alternative licensure pathways that exist in other jurisdictions, noting that many include exam components and all have reviewed elements that are based on standardized criteria. Finally, the claim that the bar is an objective and controlled test is misleading. It has been well documented that the experience of individual exam takers varies greatly, and it depends on where you take the exam, who the proctors are, if the examinee's request for an accommodation is granted, and the fact that essay portions of the exam are graded by hundreds of different readers. I personally have taken the California bar exam multiple times, and I can attest that the experiences that I had varied greatly on every occasion. The CLA letter goes on to claim that consumers of legal services will not be adequately protected, and there is no requirement that a person seeking to practice law in California demonstrates a basic working knowledge of key legal principles. This fails to acknowledge that by the time applicants take the bar exam, they have actually completed 3 or more years of law school and are tasked with completing many required curriculums, such as legal skills and analytical skills and foundational legal concepts. Next, as noted above, there is no evidence that licensure based on supervised practices puts consumers at greater risk. In fact, many of the jurisdictions have shared that they feel the public is more protected as new attorneys have significant. I turn to my next colleague.
Our next public comment is from Nika.
Thank you. Hello, my name is Nakia Schultz. I'm also with the Legal Services Funders Network. And just to wrap up Jen's last comment, in fact, many of the jurisdictions have shared that they feel public is more protected as new attorneys receive significant supervision and training post-law school. I will now address the next comment, which is that the alternative pathway raises significant implementation and integrity concerns. Mr. Evans, despite having attended numerous BRC meetings where data about the success of the existing pathway programs has been presented, claims that an alternative pathway could open the door to supervision by unqualified and potentially unscrupulous law firms and lawyers. This argument fails to acknowledge that these programs, including California's PLL program, have not experienced any significant inequitable access to supervisors or harassment. Furthermore, State Bar staff has addressed these concerns by identifying the potential to require standardized training of supervisors, minimum compensation requirements, ongoing monitoring of pathway participants, and a matching program that would ensure access to supervisors for pathway positions. The CLA letter goes on to claim that effective monitoring and quality control of experiential programs will be time-consuming, labor-intensive, and costly. Yet it fails to acknowledge that effective monitoring and quality control of the exam is in fact time-consuming, labor-intensive, and costly to both the State Bar and
30 seconds.
who currently are told that they plan to set aside 10 weeks prior to taking the bar exam to exclusively study, and that they will have to spend thousands of additional dollars taking bar prep courses to have a chance to pass the bar exam. Mr. Evans also fails to disclose that BRC has received public comment from numerous private funders committed to increasing access to justice and diversifying the legal profession, expressing their interest in helping support an alternative pathway to licensure, and the bar fees for pathway to participants could be redeployed to cover much of the pathway monitoring and oversight costs. My colleague will address the next concern.
Next public comment is from Jessica Juarez, but she's put her hand down. Jessica. Oh, here we go.
Thank you. My name is Jessica Juarez. I'm also with LSFN. An alternative pathway may have an adverse impact on efforts to increase diversity in the legal profession. The CLA letter claims that an alternative pathway, quote, could at least indirectly exacerbate the problem of limited diversity in the legal profession because of an unproven and assumed gap between the demand for supervisors and the available opportunity to secure supervisors, end quote. Many BRC presenters who administer fellowship and pathway programs have expressed a belief that there will be ample supervisors available, especially for licensure applicants who want to work in public interest law, government positions in small rural practices, and legal deserts. The CLA letter states the demographics of the pool of available supervisors would skew towards those who are currently the most represented in the legal profession and against those who are the least represented, inferring that the BIPOC pathway applicants would be less likely to be able to secure positions as a result. This assumption is contrary to actual data provided to the BRC about existing PLLs and fellows. Like many of my peers, I am a PLL and a person of color. On my own, I initiated contact and found a PLL position, and my supervisor is a white attorney. Many of my peers who did not already have an existing relationship with a potential supervisor or were not inclined to seek out a supervisor on their own use matching programs, similar to the ones the State Bar staff is contemplating. The CLA statements, which imply white attorneys will be more inclined and available to supervise white pathway applicants,
30 seconds.
are the unsubstantiated, outdated, and offensive opinions of people who seek to avoid exploring an alternative pathway to licensure. I yield the rest of my time to my LSFN colleague, Claire. Thank you.
Our next public comment is from Tyrin.
Yes, good morning. My name is Tyrene Amon. Thank you for allowing me to provide this public comment. I am a provisionally licensed lawyer currently in the provisional licensure program. The California State Bar exam purports to test an applicant's minimum competence to practice law and an applicant's ability to address issues in a lawyer-like manner. I believe the commission should seriously consider allowing current provisionally licensed holders an untraditional pathway to licensure at the expiration of the program. I believe that it will be undeniable for the commission to see that after two successful years of practice as a provisionally licensed lawyer, definitely tests an applicant's minimum competence to practice law in comparison to a two-day exam. I venture to say that this non-traditional path will be fair and sensible. Provisional license holders have been entrusted with temporary licensure and would have essentially took a 2-year test of competence at the expiration of the program versus a 2-day test. This is important, especially for those who face great challenges with standardized testing. Additionally, provisionally licensed lawyers will have had provisionally licensed lawyers will have more experience verified experience at
30
that at the
seconds.
hands of supervising attorneys. If the state bar allows licensees to become non-traditional yet permanently barred attorneys than someone taking the bar exam right out of law school and directly going into practice. In my case, I have now attempted to pass the bar several times, have been required to take off work to study for the bar, which has put me in serious financial strain, and have come within mere points of achieving a passing score. Yet I have still actually led my first trial as first chair and opposed successfully several MSJs, many things that my firm
I'm
and
sorry,
my
but your
colleagues
time
have
is up.
seen that I have competence to practice law. Thank you.
And the final public comment is from Claire Solid.
Good morning. I'm Claire Solat. I oversee the LSFN and its public interest law fellowship. I am extraordinarily proud of all of the speakers that we heard today, including our last speaker, and very appreciative of the effort to increasing access to justice. I assure you my comments will not exceed the time that I'm allotted as well as the time that's.
Claire, I'm sorry to interrupt. It's a little hard to hear you. It's getting muffled.
Is that a little better?
Yes.
Thank you. I will conclude in respect to the comments that were in the CLA October 11th public comment letters submitted. CLA's public comment ends with a statement that the BRC should pursue other potential reforms to the bar exam itself instead of exploring an alternative pathway and eliminating the bar exam entirely. This is likely the most clear example of the author's calculated attempt to mislead their audiences. Mr. Evans is well aware that he and his fellow BRC members voted to revise the California bar exam as part of their work on the BRC. Throughout the process, the vision has always been to consider more than one method of licensure. The BRC for the past 2 years has been studying and evaluating both changes to the bar exam and an alternative pathway that could quite possibly include an exam component such as the Ontario program, which requires applicants to take a 3 to 4 hour multiple choice open book test as part of the requirement for licensure. This sounds very similar to what our last speaker advocated for. At no point has the BRC recommended elimination of the bar exam entirely. Therefore, it is shocking to see this false statement made.
30 seconds.
Does that include the extra time that was yielded to me?
Yes.
I'm a member of CLA and its public law section. Public interest attorneys, as LAC mentioned, were not represented when CLA decided who to put in its 3 seats. The CLA later is a blatant attempt to bias the members of CLA and the BRC against considering an alternative pathway to licensure. Again, this nomenclature of a non-exam is not correct. That has never been what was recommended, suggested, or asked to be considered. Based on the facts and data, it is likely that an alternative pathway would increase access to justice, increase diversity in the legal profession, and allow California to join other jurisdictions that have recognized that it is.
I'm sorry, but your time is up.
I'm concluding to provide more than one way to become licensed as an attorney. Thank you for your time.
That concludes public comment.
Before we turn to, thank everyone for the public comment. Before we turn to the minutes, I'd be remiss not to make a couple of quick comments. Number one, I very much respect public comment. I know this whole commission does, and it's find it to be a productive part of our deliberations. That being said, I personally, as chair, do not find personal attacks to be productive, and I would respect everybody in that process to try to keep that in mind as we move forward. What I'd like to do is first see if we can approve the minutes and then move on to business. Is there a motion on the table for the approval of the October 13th, 2022 minutes?
I'll move.
Second?
I'll second.
Thank you. Second, Natalie. Devin, can we take a vote on the minutes, please?
Yes. Susan Bakshian,
Approve.
David Boyd, Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans,
Yes.
Jackie Gardina, Ryan Harrison,
Yes.
Dr. Henderson,
Approve.
Esther Lynn, Tracy Montez,
Approve.
Judge Reeser,
They're accurate. Approve.
Natalie Rodriguez,
Approve.
Kristen Rossi,
Approve.
Emily Scavalletto,
Approve.
Karen Silverman,
Approved.
Mylan Spencer, Amy Williams.
Approved.
The motion passes.
Thank you, Devin. We're going to move to item 2A in business. As we do that, I'm going to turn it over to Amy Nunez to walk us through some of the out-of-state and foreign attorney issues for discussion. I do want to just get a little more detailed into our time frame and timeline for everybody. Our intent is to have this be the last meeting of the year. Where we finish off today, we will have a draft report put together. We will reconvene to look to do that in the beginning of 2023, early in the year if possible, to review and approve that report and send it out for public comment. That is currently the schedule that we're working towards. And so we're going to try our best to stay on that timeline. Amy.
Thank you, Josh. All right, so today we can get to the next screen. We're going to talk about a pending item that's left under the exam pathway and specifically looking at do attorneys from other jurisdictions need to sit for the full exam? This is one of the questions that was posed that the Supreme Court directed the commission to look at. So as we do that, I think it's important, if you go to the next slide, please, to look at the principles that were developed early on by this commission, and this will help guide the decision-making here. So there are a couple of relevant guiding principles that should be considered when looking at how to treat attorneys from other jurisdictions and foreign applicants, and that is the admission to the State Bar of California requires a demonstration of knowledge, skills, and abilities currently required for the entry-level practice of law, otherwise referred to as minimum competence. And the second principle is criteria for admission to the State Bar of California should be designed to ensure protection of the public. And so I think these are two principles that everyone should keep in mind as I walk through the options for the commission's consideration. Next slide, please. So one of the pieces of information that might be helpful to the commission on determining whether there's sufficient evidence that an exam is not necessary for this applicant pool is looking at this 10-year pass rate. So this is a pass rate for exams between February 2012 and February 2022. What we're looking at here is the 10-year average pass rate, and I'll explain each of these. So starting with the foreign educated, these are foreign educated applicants, meaning that they have a JD from a foreign jurisdiction, and that JD is based in common law, but they have not practiced in their home jurisdiction. The foreign attorneys are attorneys from obviously out of the country, and that have, again, a foreign law degree based in common law. And US attorneys are those attorneys that are licensed in another jurisdiction in the United States. And as you can see here, for that period, in that 10-year period, there are 2 points of comparison here. This is a 10-year average pass rate for all takers. So the bar exam is the next item. So 42.8% passed the bar exam. And that bar exam is the 2-day exam. And then the next item is, the next statistic here is all takers that are attorney applicants. So 44.2% was the pass rate for attorney applicants altogether. So if you look at the pass rates for foreign educated, it's 15.1, For foreign attorneys, it's 20.6. And for US attorneys, it's 54.1. So that, as you can see, that US attorneys score above the rates of all takers as well, whether it's for the bar exam or the one-day attorney exam. So this is good to keep in mind as we consider what our options are for foreign attorneys or attorneys outside of our jurisdiction in California. Next slide, please. So one option is to keep the status quo. And so at previous meetings, we've discussed what the current requirements and are for each of these attorney types. And so the first is important to know that there is no admission on motion. All applicants, regardless of whether you've been licensed or not in another jurisdiction, must sit and pass the California bar exam. And so a status quo here would mean that out-of-state attorneys will continue to be required to sit and pass the newly formulated California bar exam, potentially. Out-of-country applicants, and again, that meet the requirements, which are to have a first degree from a common law country and have practiced in their home jurisdiction, they would be also eligible to license in California as long as they sit and pass the newly formulated bar exam. And then for foreign educated applicants that have not been licensed in their home jurisdiction, the status quo would mean that they would have to sit and pass the newly formulated California bar exam. So again, this is if we were not to change any of our policies. Next slide, please. Here are options if we were to open it up to admission on motion. So in this scenario, out-of-state attorney applicants from US jurisdictions can be admitted to practice law in California. One thing to consider is in other jurisdictions that allow for this, there's a minimum number of years of practice that are required. And so that could be one of the commission's considerations. Also, the commission may want to consider allowing foreign attorneys the ability to the same courtesy. But again, I think the pass rates also need to be considered. And also the fact that these applicants from foreign jurisdictions have not sat for the multiple choice portion of the bar exam, so the MBE. So that might be something that gets factored into that determination. And the other things to consider is, would the commission be open to admission on motion, regardless of whether this is granted to attorneys from California? Because currently this is not granted to California. And what if other states limit granting this privilege only to California attorneys that have graduated from ABA law schools? Would that change the commission's position in determining how to treat attorney applicants from other jurisdictions? Next slide, please. So if changes to the status quo could include a possibility is that we allow out-of-state attorneys admission to practice law in California. And this could be based on a number of years. As I mentioned, in other jurisdictions that uses practice, the average is somewhere from 3 of the last 5 years. That's a very common approach, or 5 of the past 7 years. That is, if you have practiced in 5 of the past 7 years, or 3 of the past 5 years, that would allow you to be eligible to practice in that state and be admitted without having to take the bar exam. The commission could also consider whether to limit the licensing privilege to applicants from jurisdictions that offer the same ability to California from all law school types, or simply offer this to jurisdictions that recognize also attorneys coming from non-ABA law schools. The other proposed changes to allow out-of-country attorneys admission to practice law in California. Again, it could be based on the number of years of practice. So again, the commission should consider also whether bar exam performance should factor into any of these considerations. Now, the next screen, the court also has asked us as part of the considerations of an exam alternative pathway is to determine whether an exam alternative pathway would be open to out-of-state attorneys or graduates from non-California law schools. And, you know, if in the event that there one is developed, and I think we've concluded that at least maybe we'll open it up in discussion, but next slide, please. I think the consideration is, should out-of-state attorneys and out-of-state out-of-country attorneys be eligible to participate in a non-exam pathway if that model were to be recommended? So I think we should, I'll open it up now for questions. If there are any questions about any of the considerations or any follow-up about our current process and how that might impact any potential changes. Neil.
Yeah, hi. Thanks for this for the presentation. Yeah, the only thing I'll note is that I think there is some impact by the court's lowering of the cut score in terms of U.S. attorneys passing the exam. In the materials, if you look at the exams given after that, the passage rate is more like in the 70s, I believe, for U.S. attorneys.
Yes. Yes, it positively impacted the pass rate.
Right.
All right,
Kristen?
Thanks. Thank you, Amy, for that. Just a quick question. If memory serves, and I may be wrong, but in addition to California, is there only one other state, and I think it's Massachusetts, that licenses attorneys that don't go to ABA law schools?
I think there might be two. It might be Vermont. Let me pull that slide up. 1 second.
Well, while you're doing that, let me ask my follow-up question.
Sure.
If you can multitask.
Yes, I could.
Do we have a sense of how many licensed attorneys out of state went to the ones that are applying and taking the California bar exam for admission here went to those other non-ABA accredited schools?
No, what I could do is if you open the slides once more, Tyler, please, and go to slide 15. This gives you a sense of the distribution of it's 20 years worth of applicant data that's looking at who has sat for the bar exam in the past 20 years. And it'll give you a sense of how many are applicants from California law schools, out of state law schools, out of state attorneys, and attorneys from foreign out of country.
Okay.
And I will continue looking this up. So as you can see here, the greatest proportion are from California law schools of those that sit for the exam. Out of state is the next largest category, followed by, excuse me, out of state attorneys.
Okay. Okay. Yeah, and it's possible that, I mean, the question I'm asking is so granular that you wouldn't necessarily know off the top of your head, but I guess I'm looking at those two columns and wondering how many went, as we contemplate, you know, whether this applies to only ABA schools or non-ABA schools as well. I just wanted to know if we're really talking about a large number of people or a small number of people.
Of that allowed non-ABA graduates.
No, I think what she's asking, Amy, is of the, I guess, in the out-of-state attorney column, what percentage of these folks attended a non-ABA law school?
Oh, yeah.
And I'm sure that's data we could generate, but I'm pretty sure we don't have it at our fingertips.
Yes, we
Thank
don't.
you, Leah. That is,
But
Thank you.
in general, California is one of 4 states that allow that have a law office study program, right? So those would be folks who did not attend an ABA law school, and then there are just and the other ones are small, and then there are there's, I feel like Tennessee has a non-ABA law school, but very, very small numbers. So I would expect the percentages to be pretty small in direct response to that question.
thanks, Donna.
Amy, Natalie, before we go to you, I'm just trying, there's a lot going on in this conversation. So is it possible, Amy, that we just focus on out-of-state attorneys first and we'll move to foreign next?
Sure.
If that's okay, let's try to parse. And then if it is a run over between the questions, let's get to it towards the end. Natalie, is your question specific to out-of-state attorneys?
It was just a follow-up to Neil. So Neil pointed out that there was a big uptick for the out of state, not foreign. And I'm wondering if we saw that same uptick in the foreign, just so that I can have that comparison as we're looking at these numbers. Was there a similar?
Yes, there was an uptick in the number of applicants. And again, you know, at the time that the cut score was lowered, and that was for the October 2020 exam, that would have been the July 2020 exam. The next 3 exams after that, that is February 2021 and July 2021, were remote exams. And that also contributed to a higher amount of foreign attorneys applying and taking that exam, as well as out of state. So
And passing, Amy, though, so it was like a 20-point difference, it sounded like.
yes. In the report, I have the full statistics for that, for each of the periods, because what I've summarized here is the number of a 10-year average. So let me pull those statistics up. I have them. Draw a copy.
Just to Amy, just to clarify the conversation, during that time, there was a increase in applicants. I think that practically makes sense as it was online. It was easier for folks to take from a foreign standpoint. And you believe, but you're going to look up the statistics, that there was also an increase in passage that may have been contributed, but not necessarily, to the lowering of the cut score or changing the cut score. Is that accurate?
Yes, that's what I'm trying to confirm right now.
Okay.
All right.
Yeah, and all the data is on our materials. It's the attachment B, I think, for today's agenda.
Okay.
It's okay, Josh. I don't think we have to wait for that stat to continue the conversation on the out of state.
Okay, but I do need Amy for it. So Amy, let's if you're continuing to look that up, if you find it, let us know.
Sure.
In the meantime, let's focus on the out-of-state attorneys and you know, any changes from status quo that people are interested in seeing, or questions on what occurs today and how we may improve it. And then we can move on from there. Yeah, Emily?
So my understanding is that the status quo with our current exam is that out-of-state attorneys only need to take 1 day of the 2-day exam. Is that correct still?
If they have practiced for at least 4 years from the date that they want to sit the exam. So you need 4 years of practice to be eligible to sit for the 1 day. Otherwise, you sit for the 2-day exam.
So am I correct? You're essentially not treated as an attorney applicant if you don't have that 4-year mark?
Correct.
So you would just be a law school applicant essentially?
Yes.
Okay. So if we did the status quo with our new exam, we obviously don't know yet sort of what pieces of that exam will be. But my understanding would be then that if, again, status quo, we would still have that 4-year threshold. Anybody under 4 years would have to take the full exam. And then we could make a recommendation to the court that if we stick with this 4-year with the new exam, that somebody, not us, look at what piece of that exam would be appropriate for non-attorney, out-of-state attorney applicants. So that's one way that we could go to keep status quo. Is that right?
Correct.
Okay. Thank you.
Sure.
Judge?
So I have a question. Under the current status quo, when we define 4 years of practice, is that somebody who is licensed in the full-time practice of law and working as such, or is that someone who just passes the bar in a different state and occasionally writes a letter for his or her relatives or friends?
It's 4 years of practice.
So it could run the entire gamut as opposed to drilling down on exactly what that consists of.
Correct. And I also want to answer the question about whether other attorney types had the same uptick. So yes, so in February of 2020, the pass rates for U.S. attorneys increased compared to other years. It went from 53% on average to about 74%. But, and I know we're not going to talk about foreign attorneys yet, but that was not the case for foreign attorneys. There was less of an increase for the October, for example, 2020, February 2021, July 2021, and February 2022, meaning that the cut score did not impact the foreign attorney categories as they did the U.S. attorney category.
And Amy, in your experience, this is just more out of curiosity, are there any recommendations that you would make with regard to out-of-state attorneys and the way we treat them now, as far as years go? Or I know the conversation we had before as a group that I think was driving our kind of decision-making was the possibility of reciprocity. And so I'll just bring that back into the fold for a moment. There was a conversation about the need to be able to not only operate in other states and practice in other states, but for other attorneys to be able to practice in California. And was there a need for us to maybe find reciprocity with a admission on motion with some states? I know that's something that we've never done or considered. I don't know if that's a conversation we want to have today. It seems so far in this conversation that people are pretty comfortable with the current status quo. And so I ask if there are any other items that we want to take up on this or conversations around it, or if we're comfortable staying where we are and making a recommendation of status quo.
So Josh, I think one of the considerations when it comes to reciprocity, so if the commission were to recommend a reciprocity as a method to allow licensing of incoming attorneys from other jurisdictions, that would also require that jurisdiction allow U.S. attorneys from California the ability to get licensed without having to sit for the exam. And I think what's embedded within that is also the consideration of how non-ABA law school students are treated. So part of that could incentivize other states to allow to be open to non-ABA law schools if we want to add that caveat to that recommendation too.
Has that ever been a conversation? I do know from the map that you supplied and that you showed us before that the reciprocity does exist between some states is limited to ABA schools. That makes sense, as most states have only ABA schools. Has there ever been a conversation, Amy, with other states regarding the non-ABA schools? And is there, how's the reception been to that?
So I think in preparation of that map that we put together for that presentation, which I could pull up if anybody needs, but in preparation for that, I reached out to each of the jurisdictions to see how much they'd be open to California opening the discussion of reciprocity with California. And I think right now, all of the jurisdictions are in transition. You know, some jurisdictions will be adopting the next gen exam, and some are going to continue with an alternative if they're not using an alternative, or at least creating commissions similar to this one to explore that. So it's a hard answer to, it's hard to answer what's going to happen in the future, given that, for example, if you're in the next gen exam, if you adopt that, there's a possibility to do that score portability, whatever the case that might be, that exists now. And so, and then, you know, the fact that some jurisdictions don't know ultimately what their courts or what their boards will end up doing, that is adopting the next gen or continuing without it. So I really didn't get solid answers on that. I think we have to wait a bit to see what direction people are moving in.
Okay. Ryan?
Yes, I'm just curious to hear if anyone or any organization has, or any state has troubleshot the idea wherein an out-of-state attorney who's been practicing for 5 years works with a California attorney for 1 year. The California attorney then vouches for that person to the regulating bar entity for admission, and then they're admitted. If there's been any issues arising out of that type of scenario that have been identified by other organizations when you guys looked into the various ways that a reciprocity situation can be established. Did that make any sense?
So one of the things that we do know, Ryan, is that Oregon, in adopting sort of in adopting an alternative pathway, as well as what they're going to do going forward for permanent licensure, they did say where there's one experiential pathway where certain things will happen in law school, but then they created a supervised pathway for out-of-state attorneys who, instead of taking the bar exam. So it's certainly a model that exists out there. I don't know that we've got any, I don't know that it's in place anywhere, but it's certainly a model that exists, and it is sort of one of the things that, that can be done sort of irrespective of whether we have a supervised pathway, an exam alternative pathway for California law students, but that is certainly an option that exists.
Yeah, thanks.
Neil?
Yeah, just sort of that, I hate to complicate things, but I also wonder whether when we're looking at the map in Exhibit A about the states that have various forms of reciprocity, I wonder whether the red and blue states, hate to use that terminology, but I'm wondering whether the red and blue states line up roughly with whether those same jurisdictions also use the NCBE's uniform bar exam. So that's just an additional factor that I'm throwing out there in terms of consideration.
Amy, can you share the map? Yeah, thank you.
Yes, here it is.
I appreciate it.
Here's the map.
Leah?
Well, I guess I have a question. It kind of follows on your question, Neil. I'm not sure exactly how that's relevant. Well, in this sense, I would like the commission to take this topic on from the vantage point of, do we want these red states? And I think I'm correct in saying, is it only the red states that would require, and I forgot the difference between comity and reciprocity. Basically, in order for our licensees to be recognized in those states, we would have to recognize their licensees. Is that only the red states?
Yes, that's reciprocity.
Okay, so in all the other colors, can California, except orange, can California licensed attorneys go practice right now without taking an exam in all from ABA graduate in all these other states except the orange ones?
Yes.
So it's the red states that are the issue. Right, where because we don't recognize them, they won't recognize us.
Correct.
All right, so my ask of the commission in terms of generating a recommendation is, do we want it to be easier for our licensees to be recognized in these other jurisdictions because there's some value there? One way to do that, I think, Neil, is by everybody in the country going to the UBE, but another way to do that is we have our California exam, but we recommend to the Supreme Court that you do recognize licensees from other jurisdictions with the understanding that then we will get the portability benefit of the UBE without actually having to adopt the UBE, simply because our state recognizes the licensees from other states. So, I mean, I think Josh, you said it sounded like everybody was comfortable with the status quo, but the status quo is we don't have the portability that we could have if we implemented reciprocity. And so I think the commission needs to consider that, because to me, portability is the very important goal. So that's my comment.
Yeah, I mean, we've had that discussion over the last year, and I think that if I can summarize it, I think people agree with you that it is important, and portability is important. I think there's just a really difficult division, it appears, between ABA approved schools and reciprocity. And I guess I don't know. We won't know unless we try. Would be my answer. If the goal of these recommendations turned out to be that we wanted portability and it needed to do that, we needed reciprocity, then we would recommend that we go and speak with each of these states in an attempt to do that. We being the state of California, the bar with the Supreme Court's approval, that we would do that. And then I think we would need to make a recommendation on, or maybe make a recommendation with regard to ABA approved versus if that was the sticking point. Donna, do you agree with that?
Mostly. I just want to. I would not expect any state to be able to commit at this point, because we are talking about completely changing our exam, and so I feel like the decision sort of needs to be made was maybe we pull it apart to should California license attorneys from other states without them having to sit for the California exam, right? And then you break that apart with only if they let all Californians sit for their exam, or license all Californians without sitting for their exam, or regardless of whether they let all licensed Californians into their state without taking an exam. But I feel like we need to know the overarching sort of principles, because it would be unlikely for any state to tell us one way or the other how they would feel based on an exam that doesn't yet exist.
Okay, I'm calling Karen in 1 second. I mean, I have to tell you, there's a little bit of uneasiness here, because I think, and I'm understanding what it is now. I was looking for maybe a little more direction from staff on, what we have today and where you think we should go and for consideration. But I do understand, I think now that we don't know. Amy said that, and then Donna, you just repeated it. It would seem to me that it may be in our best interest to hold, and if any recommendation we do make, it would be one in which would need to take effect or have conversations after the next gen exam, or after other states have understand the direction that they're going to be taking with the exam. Because if your point is we aren't going to get anywhere today in that conversation because nobody knows, then I would be careful to give a recommendation that would ask anybody to do anything today.
No, I apologize if that's how my response sounded. What I'm saying is that I think this commission can adopt some principles. I mean, I know Judge Reeser spoke eloquently at past meetings about his strong belief that we should license attorneys from other states without requiring them to sit for a bar exam. I think we can adopt those principles. We won't know necessarily that other states will confer reciprocity, right, to us if we make that decision or that recommendation to the Supreme Court that we allow licensed attorneys to become licensed in California without sitting for another bar exam. But I think I really think we can and we should set the overarching principles of what we believe should take place. And sorry, Judge Reeser, for putting you on the spot, but you've spoken very strongly about this in past meetings. And so I mean, I do think that there are at least some number of members of the commission who have some strong feelings about the competency of lawyers the people who've demonstrated their competency in other states, and whether or not there should be a bar exam, sitting for a bar exam as a hurdle to becoming licensed in California.
Okay, Karen?
I'd rather hear from Judge Reiser first, if you don't mind. But...
Judge?
So it seems to me that, and perhaps this is just your jurisprudential, but our job is to do the right thing. And this isn't a negotiation with other states. Our job is to allow in those applicants who are qualified, or at least satisfy the levels of minimum competence that we utilize in order to bring people into the fold. So California exceptionalism notwithstanding, I think that we ought not defer any decisions based on what other states might or might not do, depending on how they view reciprocity or how they view California. I think our job is just to do the right thing for our citizens and for our attorney applicants from wherever, including the domestic US. So yes, I feel strongly that if someone is competently practicing law full-time in another state without any complaints with respect to their ethics or their competence, and they've done it for a period of years, which everyone agrees to, why would they not be competent to practice law at a minimum level of competence in California? It doesn't make any sense. And the only reasons we have done it, in my perception, are because of some, trade guild kind of concepts, which I think are antiquated. So yes, I do feel strongly.
Karen?
So I actually share Judge Reiser's perspective on this, but wondering also if has there been any effort for lawyers who are newer to the practice for us to sort of evaluate, and this would have to be sort of a moving target, what the equivalence of passing a California level bar would look like, right? So it's not just enough to have passed the bar in another state, but have they passed with a score that we have established is more of an equivalence, right? And the only thing I'm worried about that, I think, is what everybody's worried about, which is that we're not diminishing or diluting a standard or opening up an opportunity for essentially arbitrage, right, of bars and as long as we're defending against that with reasonable policies, it seems to me this is a pretty straightforward question that we can at least discuss the outlines for today.
Yeah, unfortunately, I think it's a little more complicated than that. I mean, I think the judge's comment in its broad terms, I absolutely agree with. I guess the question is, how do you prove competence? And so, Karen, in your comment, you went back to proving competence by a certain passing grade on an exam. I think the judge is saying they've proven their competence, and I apologize, I'm putting words in your mouth, by being a practicing attorney and doing a good job at that over a certain period of time. And so I think we have to decide where is that line of competence? How many years of practice is that? And then, or do they just have to come take the exam? shortened or otherwise, 4 years and shortened exam, or, you know, under 4 years and full exam. Emily?
So I guess I have two thoughts. One is that if our basis for admission is still minimally competent attorney, and on our standard is 4 years of practice, and yes, granted, that could be, I'm a trust Will's lawyer that wrote one letter one time, but I do think that what I don't believe is the case is that the state bar admits out-of-state attorneys based on whether or not they pass the bar exam. So for example, I believe somebody in Wisconsin who doesn't take an exam could just after 4 years of practice come and take our bar exam. Is that right? So it's not like we have to look at somebody else's bar exam, correct?
Yes, we do not look at other bar exams.
No.
They have to come and take this one.
So essentially, if you've practiced for 4 years, you can take the 1-day bar exam. I would just say that I don't know that it matters as far as whatever other bar exam they would have taken. At least it hasn't, and that hasn't seemed to be a problem. My concern is that we are going down a road of providing out-of-state folks maybe even more access than our own in-state folks, that we would be saying to somebody who is not able to pass the bar but could be an excellent attorney, if you go and practice in another state for 4 years, then you can come back to California. And I would really not like to do that, right? Our PLLs and other folks that have been working as attorneys for however long it's been, are they not yet considered minimally competent? If they were able to do that for 4 years, would they be minimally competent? Is it the bar exam that we required that makes it so we feel better about minimum competence? So I have a lot of questions as it relates to, are we doing a disservice to our own California folks by saying, don't worry about the exam if you go to another state? I also, at the same time, feel like reciprocity is important, and that portability is going to be important to attract folks to California law schools, selfishly, and also just kind of the way the world is going to work, right? That is less a concern for me as it is to making sure that our California folks are able to access admission to practice law in the state that they've chosen, that is not harder for them than it would be for out-of-state folks.
Any other thoughts on out-of-state attorneys? Okay, we're going to come back to it, but let's keep moving for the moment. Amy, you want to just give us a quick thoughts on foreign attorneys as opposed to foreign educated? Just a quick review, and we can start a discussion on it.
Sure. So I think it's important to remind the commission that foreign attorneys now have to sit and pass the 2-day exam, not the 1 day. And again, it stems from the fact that they have not completed the MBE. So the MBE is the 2nd day of the exam. So they're required to sit for the multiple choice. And when you look around the country, how other jurisdictions treated, California aligns in terms of the practice, meaning that in other jurisdictions, about 35 jurisdictions allow attorneys from other jurisdictions of foreign countries the ability to sit and pass the exam as long as they come from, they have a first degree in law, and also that it's based in common law. And so in some ways, California, its treatment on foreign jurisdiction applicants is similar to other states.
Okay, thank you. Does anybody have any thoughts on any changes they want to discuss, improvements, or back to, are we comfortable with the status quo that Amy just described? Okay, seeing none at this point, let's keep going. Amy, what about foreign educated applicants? I'm sorry, and foreign attorneys. It doesn't. There's no distinction on how long they've practiced. It makes no difference.
It doesn't.
Okay, and what about on foreign educated applicants that are not yet practicing in another
Yes.
country?
So right now, the requirement for foreign educated applicants is, there are some prerequisites. For example, your foreign law degree has to be evaluated by an outside agency to ensure that it meets our requirements. But once that's been established, applicants obviously have to sit for the 2-day exam, but also they're required to take a complete either an LLM or 1 year of education in an LLM program, so 20 units. If, for example, it's determined that they don't have a first degree in law, that they will have to either apply and take a JD program, complete a JD program in order to complete their educational legal education requirement, or they could also participate in law office study. So those are the current requirements for foreign educated applicants. And here we're looking at whether we need to revisit those requirements, or how the relevance of the foreign educated applicant is also for the non-exam pathway, which I know, again, I want to highlight that we have not come to consensus on that recommendation. But the question here is whether they would be eligible for that participation in that program, as well as out-of-state student applicants, law student applicants.
Yeah, unfortunately, it'd be premature for us to have that discussion. So
exactly.
I'm gonna table that for another day.
Okay.
I'm gonna go to Judge in 1 second. I'm a little confused in your comments, the difference between a foreign attorney and a foreign educated applicant, in that one of them, it sounds like we actually look at the education, and one we don't.
Oh, no, we do. We evaluate the education in both.
Okay.
But we just want to make sure that for the applicant attorney, the applicant who has not practiced yet, that an evaluation's been conducted about their degree. We validate the foreign attorney by getting a certificate of good standing in their home jurisdiction.
And there's no time limitation between moving from one to the other. If you're practicing for 1 day, you've moved into the foreign attorney versus foreign applicant.
No, we need a certificate of good standing. So if somebody's practiced for 1 day and they're able to get a certificate of good standing, then yes, we would accept you as a foreign attorney applicant and not a foreign educated student applicant.
Okay, Judge.
So just some clarity, please, Amy. Did you
Sure.
say that if a foreign attorney who's practiced 4 years in a common law jurisdiction, let's say you're a barrister in Vancouver, British Columbia, or you're a solicitor in London, whatever you are, that you have to come, if you want to practice here, you have to take the full bar or just the attorney bar?
The full bar, if you're from a foreign jurisdiction outside the US. And it has to do with the fact that the MBE they have not sat for the MBE, and they would have to take the essays, the PT, and the multiple choice.
And that's because the law is so different between Mississippi and England, or what?
Yes, potentially.
All right.
So I think, Judge, you raise a sort of an interesting point that we didn't sort of parse with the out-of-state attorneys in terms of who has to sit for the 1 day versus the 2 day. And it keeps, my mind keeps being jarred by this fact when Amy is talking about for the out-of-state, the issue is that they hadn't taken the MBE. So the people who are theoretically closer and closer to the knowledge that they had when they got the score that they did on the MBE are the attorneys who've been licensed for less than 4 years. But they're the ones that we require to take the 2 day, to take the 2 day exam, to retake the MBE. Whereas those who have been practicing longer I think we say you have, through your practice, essentially established some level of competence. So we're not going to require you to take the MBE. But in my mind, I strain to see the logic in terms of who qualifies for the 1-day exam versus the 2-day exam, because it feels reversed to me for the out-of-state attorneys. So I think sort of you raise an interesting question of, should any attorney, licensed attorney, be required to take the 2-day exam versus the 1-day exam? Of course, if a future exam doesn't involve an MBE, that becomes somewhat of a moot point.
It just seems so odd to me because in the 1980s, right, my firm hired a barrister from Ireland who was a trust and estates attorney, right? And the law is the same because, that's my field. And she had to sit in those days for the 3-day, I think it was, exam. And it made no sense because she'd been practicing for 10 years, perfectly competent, and it was just a waste of 6 months. It was silly, but maybe that's just the fallout.
Okay, I mean, I think we have covered the different possibilities here, or the three different groups. I guess I would ask, is anybody interested in seeing any changes in what occurs today, or are we comfortable with no recommendation?
So Josh, I kind of wanted to share Judge Reeser's previous comment and kind of put it into a potential motion, right? So just so that we can look at as a group of the potential change that Judge Reeser was proposing. But let me share it. I'm not trying to impose a motion here, but the idea that you described, Judge Reeser, was the beers that out-of-state attorney applicants from all U.S. jurisdictions could be admitted to practice law in California without having to pass the California bar exam. And then I think what would be outstanding is, should that be based on a number of years of practice? And I think one of the things about this recommendation is when you look at the pass rates for U.S. attorneys, I think that we can all agree that minimum competence, because it's our current, framework, is the bar exam as a measure for that, is safely met, right? When you look at the pass rates that we did that comparison. So I just want to put that out there as an idea. This is, this would be a change from the status quo.
Could I possibly, I'm sorry, could I possibly amend that, Amy?
Sure.
To say a number of years of full-time practice with no history of ethical or competence issues in a foreign jurisdiction.
Okay, so
something along those lines.
Sure. So you said based on a number of
years of full-time practice.
And another thing to consider too is when you mentioned as long as there haven't been any complaints, is that a current requirement is that you need to be in good standing in your home jurisdiction, as well as having met the moral character requirements determination here.
I think it's more than that. I think it's, having your nose clean in, if there's complaints and they resolve out in some form or fashion, that I think is relevant to whether the state bar decides to require these individuals to take the bar, the California bar.
And
Amy?
Yes.
I'm gonna stop this conversation for one moment, please, because and it may just be that we haven't had a lot of conversation right now as a body. I didn't have the feeling that there was a lot of interest, and I don't want to spend a lot of time on it if there isn't. So I would ask if there are some members that a version of this interests them to please speak up. with, you know, any kind of changes, or if it's something that you are interested in having a dialogue on. Otherwise, I think we will probably move on, because it's didn't appear to me there were a lot of folks interested, but nevertheless, let's see what we hear. Susan?
Sorry, I just wanted to chime in and say, this is Ryan Harrison. I'm very interested in this. Oh, yeah.
Okay, great.
Susan? Thank you. I'm also very interested in change here, and also interested in talking about the specifics. Number of years and types of discipline or good standing that's required, I think, are an important consideration here. But I also think it's important to talk about how this particular kind of change would or would not impact. We have a bunch of existing exceptions today in California for military spouses, qualified legal services, in-house counsel. And I would like to see those exceptions expanded. And so I would also want to add that to the conversation and to our concerns.
Great, thank you. Karen?
I guess I have two comments. One is that I would actually make this a little bit less, well, more aspirational and thematic, and say that what we want to do is revisit and revise standards that accommodate out of state and out of jurisdiction applicants consistent with the new standards that we're developing for California, whether that's exam, going back to that last, what we don't want to do is dilute or change, or for that matter, amplify the standards that we're still developing internally. So I think, to Donna's point, some more consistency across these application and candidate pools is what we ought to be expressing a desire to achieve at this point. And the second thing is, I just have to say it, full-time practice is going to disadvantage women who take leave or whatever. So we are going to have to figure out a way to express that, I think, in a way that acknowledges the diversity of people's careers and career paths, even after they're admitted to practice.
Other comments, thoughts? Karen, I too am struggling with full-time practice. I understand the concept and the need to have somebody show their competency, but trying to define it with all of the potential exceptions and is going to be very, very difficult.
Agreed.
Susan?
Perhaps instead of full-time practice, we want to consider terms more like a requisite number of hours of practice.
Which would need to be also substantially in excess of the hours we were considering around the alternative pathway. Right, this is what I don't want to do is start to create and introduce inconsistencies and loopholes that we don't intend.
Yeah, I see some difficulties in that also. Susan, are you suggesting hours on an annual basis, or just hours that you've practiced?
I mean, I'm trying to find a way to get to the judge's concern, which is that we are not going to take an out-of-state applicant who has essentially not practiced. But I do think there's probably a variety of ways to measure that. And I think we likely don't need to have those numbers or years or exact data now to be able to put forth a recommendation that perhaps simply acknowledges that the BRC recommends an expansion of reciprocity and an expansion of access for out-of-state attorneys.
Right, that is consistent with the standards we're establishing for in-state licensure.
And I would also caution, when I hear hours of practice, full-time practice, to me, that sounds very much like a private law firm is how we're defining that. And there are many different ways to utilize your law licensure that may be harder to quantify in non-private law firm settings.
I do think, and I'm curious to hear from more members. I do think a a broader statement about the desire for expansion and the desire to find reciprocity would be something that it's probably a shared goal. I think the parsing the language on years of practice or full-time practice is going to be a little more complicated in trying to figure out. Emily?
I would just welcome comments from those who voted no on the non-exam pathway, because this to me is a non-exam pathway. And so I'm not hearing from anybody that this is a problem. So if this isn't a problem, I'd like to hear that. If it is, that would be helpful to me.
Okay. Ryan?
Yes, so I voted no on the non-exam pathway because I want to say I already mentioned my concerns at the last meeting, but although this other thing that we're talking about today could be cast as a non-exam pathway, we need to be mindful of that we are still addressing the bar exam. And at the end of the day, I think more likely than not, it's going to be easier for California residents to law students to be admitted to practice law in California and pass the bar exam. You know, we don't know to what degree that statistic is going to increase, but I believe that when our work is done at the end of the day, more people will be admitted than are currently admitted. And so the argument that this is a non-exam pathway that non-admitted Californians could go through as kind of a loophole, like I don't know if that is an argument we can fully flesh out at this time, maybe later after the dust settles, but right now I don't think so.
Ryan, do you think that there's a need to identify any of these attributes specifically, as in number of years or full-time practice, or are you comfortable with a broader statement?
I'm comfortable with the broader statement. I think trying to work out the nuances here right now is too much. It's going to take time for folks to consider the nuances. But I think right now we just need to establish that this is something that we want, generally speaking.
Fair enough. Other comments? Okay. Amy, is it possible to work on, and we can come back to it, a broad motion?
Sure.
I'm sorry?
Sure, I could do that.
I think that may be the best approach. I mean, 1 second, Alex, I'll call on you. It feels like there's some movement for and aspirational and recommendation that talks about what we're hoping to accomplish. And so maybe we can draft something and get a little more granular on the language. Alex.
Chair, I'm actually looking at other jurisdictions and how they define the eligibility requirements. And one of them, for example, in Texas, sort of defines it as someone who has been actively and substantially engaged in the lawful practice of law as your principal business or occupation for at least 5 of the 7 years immediately preceding your application. And I really like that definition, and I would ask some of that stuff to be incorporated into this definition. So for example, I would say towards the end, if we're going to be saying based on a minimum number of years of full-time practice, I would suggest that we add in the language immediately preceding your application, for example, to ensure that what we're referring to in terms of the year eligibility is tied to their practice and not something that they did 10, 20 years ago. I think that should be incorporated. But also, I would also include the language about the practice of law as being the principal business of the applicants. Because if it's something that's ancillary, then that sort of in many ways, it's counterintuitive. And so those are the 2 things that I would recommend incorporating. Thank you.
Thank you. Susan?
I have some concerns about adding some of those specifics. First of all, we haven't done a exhaustive search of the 50 jurisdictions, and I would hate to model after just one without looking at what else is out there. But also, I share the earlier concerns that this disfavors women, this disfavors people who work part-time for a variety of reasons, this disfavors people who care for children. I'm concerned about language like principal business. Does that mean legal services does not count? That's not a business. So I'm concerned that many of these things favor private practitioners and favor very limited kinds of things that are not appropriate and would be very limiting. And in fact, contrary to the kind of broader description we've been talking about here, where I think we do have consensus, which is that broadly we should expand this. And while there may be particular details that would needed to be investigated, that's beyond the scope of this commission.
Susan, can I address one of your points, and that is in terms of background research on what other jurisdictions do. We conducted that research, and the two most often implemented policies in each of these in the jurisdictions are practice 3 of the last 5 years or 5 of the 7 or of the past 7 years. So those two frameworks in terms of a minimum requirement number of years are the most often, and that's probably represents about 80% of the jurisdictions in the United States, just FYI.
Thank you, Amy.
Okay, but the other, I want to go back to, sorry, Alex, one quick thing. In terms of your recommendation, it's a little opposite of what Josh, you were directing us to do, and that is to make a broad statement. So I think we need to make a determination here. Do we want to make a broad recommendation, or are we going back to being more specific?
Let me address it, and then I'll call on Alex. My thought process, Amy, was that with a number of these matters, and to Susan's comments, there is a lot of information that needs to be taken in and made in consideration in drilling down to the details of number of years practiced and defining what practice is, or full-time practice, or and I don't know that I personally feel, based on the information that we've been given, that I'm an expert in those. And so I was more comfortable trying to make a broader statement personally around the need to have a minimum number of years, as opposed to stating the number of years, and that we wanted to get to a certain amount of minimum competence, and what that experience would be to derive minimum competence. So that's why I made that statement. Obviously, if folks felt differently, I could be convinced differently, but I am hesitant to get too detailed. Not that I disliked the definition that Alex spoke about in another state. I just don't know all of the ramifications of it, so I'd be uncomfortable drilling down to that, a specific definition. Alex?
I'm fine with your suggestion, Josh. If you want to keep this broad and not getting into the nitty-gritty part of the definition, I'm okay with it. All I was trying to do was trying to understand, when we say minimum number of years, what are we tying it to? Does that mean someone who has whatever number of years, who had practiced 20 years ago, are we now saying they can now come back to practice, even though their last practice was 20 years ago? I don't think that was the intent of the commission, and so all I was trying to do is really define it in a way that is logical. But I defer to you, Josh.
Yeah, I appreciate the thoughts on it. I mean, I think that if anything, it clarified for folks that there's some different options, but that we will at some point here in the state of California need to drill down to what we consider to be the requirements of minimum competence and experience. Susan, did you raise your hand again?
Just one last point. I would hope that in later drilling down in that detail of number of years, that we would use our own PLL data and the 2 years of data that we will have on our own California graduates that have been acting as attorneys without discipline and without incident. So that might be helpful.
Okay, I think, Amy, if you want to take the screen down and work on something, I'd like to come back to it because I don't think we're going to get to it at this moment. We can reintroduce it and at that time take it up. But I think if we can, I'd like to just move on to start working on the other items. And then we can come back unless someone has other thoughts, and we can come back and take up that motion. So folks, Ryan, you have a comment?
Yes, can we just vote on it now and move on? Or, I mean, it's up to you. It really is.
No, please. I'd like, if there are more thoughts on this, I want to take them now.
Yes, I mean, I just feel like we could just start fresh with the new item if we just voted on it and moved on instead of coming back and resuming this art,
Okay.
Yeah.
That's fine. Here was the other option. We can take a break. It's going to take a minute. So we can take a break and come back in 15 minutes and go straight to the motion. It's just going to take a moment to put it together. So we don't all sit here while we wordsmith the first version. And we can go through that motion when we return, and then we can move on. Again, the other items I don't expect to be too long today. So I'm happy to do that. It's 11:38. Let's go ahead and take a 15-minute break, and we will come back and close out this item.
Thanks.
Okay, Devin. I think we can get started again. Donna, I see you are on, and looks like Amy is also. Amy, are we in a position where we can share some language to be discussed?
Yes, but before we do that, I want to share, some of the considerations that were in the agenda item that was attached to this, to the agenda itself. So these were the various options that were included in that agenda item on a potential that could be built for a potential motion. So the first is comedy without consideration of law school type. That is, that option would be out-of-state attorney applicants from all jurisdictions can be admitted to practice law based on a minimum number of years of practice, and the commission will determine the minimum years of practice or whether those years need to be recent. But it sounds like this is the need to be recent is a very important aspect that everybody has highlighted during our discussion today. This next item is a recommendation of reciprocity without consideration of law school type. And I think that's part of the discussion here today is out-of-state attorney applicants from jurisdictions that allow ABA accredited, California accredited, and California registered law schools the ability to become licensed in their home jurisdiction without needing to sit for the bar exam can be admitted to practice law in California. Again, the commission would determine number of years of practice and whether those need to be recent. Here, I think is where we're landing, right? Reciprocity without consideration of law school type, and that is out-of-state attorneys from jurisdictions that allow California attorneys the ability to be licensed in their home jurisdiction can be admitted to practice law in California. Again, based on a number of years, the commission would determine that. And so we built a, we have drafted a motion based on some of the discussion. So I'm going to stop and pull that motion up for a second. Oops, excuse me. And here it is. Okay. So, Josh, you talked about having a broad recommendation. So here, the BRC recommends that the Supreme Court revise the requirements to provide a path for out-of-state attorneys to be admitted to California without sitting for the California bar exam. The BRC recommends that in establishing the requirements, the Supreme Court establish a minimum number of years of licensure in another state to establish minimum competence, along with the demonstration of ethical and competent practice, because I think that was raised during our discussion today. Separately, we noted, and maybe we want to just stop here, but that we recommend, the BRC recommend there be no change in the admissions requirements for admission for foreign attorneys or foreign educated applicants.
Yeah.
But let's tackle the first one.
Yeah, let's take the first one. A couple of things. Number one, I was making that suggestion based on where I thought I heard the body desire. If I am mistaken in that, and people would like to get more specific, as an example, I think that there are places that we should discuss it, and I'm happy to do that. And I would take any comments on it. I mean, number one, whether or not we're in a position now to make a recommendation on minimum number of years, we should definitely consider that. And then, on the demonstration of ethical and competent practice, whether or not there is a timeline, as specifically as we just discussed, and Alex brought up, like as an example in Texas, that we think we should recommend. I'm happy to discuss those also. So let me begin with minimum number of years. Are we comfortable as a body leaving this broad to the Supreme Court to establish a minimum number of years? Or are we interested in adding a little bit of context and definition to that, either in specifics or in a range. Alex, I think your hand may be up from earlier. Tracy?
Yes. So is this literally the Supreme Court establishes the years, or they work with another body to come up with the minimum number of years? Because it really, again, should involve the expertise of a psychometrician. In Department of Consumer Affairs, usually it'll say something to the effect of, like, 5 years in good standing. You can come in and practice through reciprocity. There might be a state law exam, again, because our professions are different than attorneys, but typically that's what we require the last 5 to 7 years, maybe. So just wanted clarification if it's literally the Supreme Court establishing that, or taking that from another body that would recommend that.
Leah, you want to address that, or you have another comment?
Question, but it's for Tracy, if you don't mind. I was just wondering what the point is of the psychometrician in the reciprocities or years of experience analysis. Because would we be saying a certain number of years of experience is equivalent to passing the California bar exam? Or what's the point of the psychometrician?
The psychometrician can help in facilitating the discussions about those critical competencies, and how it is related to competent practice. Again, typically if a state has an exam and they have passed that exam, then you accept that they are competent, on the assessment of the exam. And I think I heard some states don't necessarily do that, but it's always good to have the psychometrician involved, because they can, again, bring you back to discussions about minimum competency. And there shouldn't be differing passing scores. I know sometimes with national exams, states will select different passing scores for their state. Well, that negates, a national exam. So typically, we would say you pass the exam, that's great. And then there is a certain number of years that are recent, as I've heard other commission members mention, and again, in good standing. But again, going back to your question about a psychometrician, they're good in making sure that the decision makers focus on minimum competency and keep it standardized for California expectations, because there's a tendency to want out-of-state individuals to have a higher standard. Hope that helps.
Okay. I'm just a little confused about the experiential requirement, the years. It seems to me the main point is we want people to demonstrate a track record, and then we'll be able to see if there've been any complaints filed against them. So I just personally, I don't know 4 versus 5 or 6 or 7. It's a little hard to figure that piece out, but maybe a psychometrician would be helpful.
Is anyone interested in having a conversation about the minimum number of years specifically, or are we comfortable with the general statement that the minimum number of years needs to be established? Emily?
I guess I would say, I don't know that I'm actually yet comfortable with this period, but if we're going to say this, I would say that the minimum number of years, if the court says it's 1, right? So somebody, again, my point earlier, somebody can graduate, go out and practice for a year in another state, come back and be an attorney in California. Granted, maybe they have to take the next gen bar exam, maybe they don't, depending on what some other state does. But I think to Tracy's point about minimum competence, we have said that a minimally competent attorney, or at least what we try to gauge when we were gauging the survey was, you know, upwards of 3 years, you know, that we were trying to see kind of what those attorneys, at least in the CAPA survey, were doing. So I guess I would at least say the 4-year restriction that we have now, but I'm not wedded to that. I wouldn't vote against it if it's not that. I'm just concerned that it's going to be a lot less than that.
Ryan?
Yes, so what I want is for a licensed attorney in another state to have been practicing for 4 years, and then an additional year of supervised practice with a California attorney, and that California attorney to vouch for that person's admission. Now, I understand that the Supreme Court, if we recommend whatever, they're going to do whatever they want to do. They're going to have their own standards. And so I'm comfortable with this broad statement.
Understood. Neil?
Yeah, I'm just curious on the current 4-year requirement to take the attorney's exam. Does anybody know what is the empirical basis behind that and when that was actually implemented? I'd just be curious to know.
Yeah, we'd have to do some research on that, Neil.
Okay.
Yes.
Dr. Henderson?
As I look at the fourth line, the minimum number of years of licensure in another state, I'm more concerned about the amount of practice a person has had rather than the number of years they've been licensed. And I guess the word licensure there troubles me. And so just need to express that. I get that there are other considerations around who the person is and the life responsibilities that pertain, but there's got to be a way to establish a minimum amount of practice that can be documented than the period that they've been licensed.
Okay, I think we'll probably dig into that a little bit. Natalie?
And this may just be too granular, but in case it's available, do we know if there's already data out there for attorneys who complaints against attorneys, do they happen more towards the earlier years of an attorney being licensed, midway, later? Like, do we have data on that? Because that to me is the only, like, I'm trying to figure out, as Leo was saying, 4 years, 3 years, 5 years, like what are we exactly gaining in each of those years? But if somebody said to me, for the complaints we have for attorneys, they tend to be 3 years out, 4 years out, whatever it might be, then I understand. We want to leave enough time in there so that if some kind of allegation comes up, we have enough time to grab that. But so anyway, do we have that data? Or is that data that we can look into?
We don't have it now, but it's something that we could gather, Natalie.
Tracy?
I just wanted to reinforce Dr. Henderson's comment about actively practicing. That is key. So yes, it's not necessarily years licensed, but it is the years licensed, actively practicing, ensuring that it's recent as well as good standing. That's all. Thank you.
So Josh, if I may make a suggestion, one of the things that we can do, if the commission is comfortable with sort of this is being part of the determination that the Supreme Court is making, then you can say number of years of active practice, as defined, basically, right, saying we don't yet know what active practice means, but that's going to be part of the Supreme Court's consideration.
Mylin?
I don't know if Donna has mooted this comment, but just a really simple concept from the world of externships where we require in order for to receive the academic credit, we require a certain number of weeks of field work plus a certain number of hours within that minimum number of weeks. So it seems like what we're talking about is both. We need some longitude, and then we need some volume, right? So I think that can be captured pretty simply by requiring both, right? I don't know whether that's what Donna just expressed. I'm a little bit nervous about something like active practice, because that seems super vague. And I do want to accommodate what I see as a very valid concern that different people are able to practice at different, put in a different number of hours a week.
Eileen, can you offer just a little more detail around that? What would you be more comfortable with other than active practice?
So to me, I would require a minimum number of years to get the time expanse, so that not to put too fine a point on it, but so that there's enough time where clients could have made complaints about a particular attorney, and those would have filtered through the system such that we know that we can feel confident that if there haven't been any, it's because they were competent. So that's a number of years. But then if you're working only 2 hours a week, 5 years means nothing, right? So a number of hours, just like we were talking about with supervised practice, you need to put in a certain number of hours to replace the taking of an exam, right? To demonstrate, to properly, it sounds like evidence, but to lay the foundation for a finding of competence, right? There has to be a certain number of hours of law practice during that separate year requirement.
Okay, Jeremy.
Hey, Josh, thank you. Can you hear me okay?
Yes.
Okay, thank you. Sorry, I'm at the International Bar Association conference. So I agree with Ryan's comments and all his comments, the comments that were just made. And then on the discipline issue, I remember working with Steve Moat at the State Bar, and he was able to collect a lot of data when it came to discipline for lawyers, particularly with highlight to solo and small firm lawyers. And I don't know, I don't remember if it was tied to years in practice or not, but I know that data is there. So just FYI. Thanks, Josh.
Susan?
I just want to agree that I don't think the word active practice is the right adjective we want to put, particularly not in a broad motion. In a broad motion, I don't think we need to have that type of restriction. We could just say that the court will establish or perhaps evaluate a minimum number of years of practice. I'm concerned about active practice excluding an awful lot of things we may not intend. I can envision someone who's been a lawyer for almost the requisite number of years, but then is a magistrate or a judge for the remaining year. That's not the practice of law. Are we not going to consider that? I think that we have some unintended consequences here. If we define active, it could be quite a bit more narrow than we intend.
Yes, Susan, I just want to address again. I was offering the breadth as I thought it would be something that would be encompassing of a lot of different people's feelings and thoughts here that we could get to some consensus on. If folks believe that, I don't mean it has to be that way. If some people believe that we need some more specificity, as I think Mylin explored in one area, I think we need to have that conversation and figure out if there's some support for it. Other thoughts on this motion or language that is not a motion, this language is in front of us, and whether or not it's something that we would want to take up. I think there are some specific thoughts that have been shared that we can probably revise the language a little bit and then and work towards something. Amy, just You're controlling this. I don't know that we need, I think you can, this is just nitpicky here, but I think you can just say the requirements for out-of-state attorneys. I don't think you need to say provide a path.
Okay.
That's probably not necessary.
Okay.
And then the other thing, the one piece that's really not here, I think it was expressed a little bit by folks, but that is, I know you removed active for a moment. I understand that, but the need for the experience to be recent. How do we address that? I've heard that from a number of different speakers so far.
One thing we could include here is maybe explore the minimum number of years of practice and their recency in another state to establish minimum competency, minimum competence. Right, so that we're still exploring that, and you don't have to define it at the moment.
Yeah, and one more comment, and then we're going to turn to Emily's. Are we trying to establish minimum competence, or are we trying to establish competence? Emily?
Oh, I'm not going to answer that question.
You don't have,
I'm just kidding.
You don't have to. I think it answered itself.
Yeah. So my suggestion on the wording of this is in the second sentence to say the BRC recommends that in establishing the requirements, the Supreme Court explore the following, and then colon, and then minimum number of years, comma, recent, recency, or I don't know if it's recent years of practice. And then sort of list the things that you want to have explored by the committee or the court. Because I think there's going to be several things. So that was just my recommendation. I would also like to know the answer to the question. I'm assuming that it is minimum competence that we're trying to, that would be the admission bar, right? For out-of-state attorneys.
Well, if you think about what we do today by requiring them to take the bar exam, and the bar exam is intended as a test of minimum competence, that's the standard that we use today, and that's the standard that we have generally defined.
And that seems like a reasonable standard for someone who hasn't practiced yet and is coming out of law school. I just don't know if it's the same standard for someone that has a certain number of years of practice. Susan?
I was just going to suggest along the wording, recency seems to me not quite what we're trying to do here. Maybe timing or years of licensure or something like that might cover the concern if we're looking for immediacy.
I don't think that is. Well, Judge, go ahead.
No, I was simply going to respond to the rhetorical question, because the discussion has centered around general competence, right? Because general competence ipso facto establishes minimum competence. So I'm comfortable with the discussion, but I'm not comfortable with removing minimum competence, because that creates a dual standard.
So I think that, again, if I'm understanding, I'm not sure we've, with this language, I'm not sure we've accomplished the need, or I believe what I heard is the need to have the experience to be more recent. Is that, am I missing that in this language?
Yeah, I don't think that's reflected.
Okay.
Yeah, I actually didn't understand your edit, Susan. I think recency is the issue. So
I agree recency is the issue. I was just trying to find a more generic term like timing or something that might make more sense in the general motion. Recency isn't necessarily clear. Recent to what? Licensure.
Can you just say minimum number of years, minimum number of,
I think for Susan, it was just word choice.
yeah.
Judge.
How about, and the dates of that practice or something along those lines, which doesn't, you know, it doesn't lay an editorial suggestion.
What if you just put recent before practice, minimum number of years of recent practice?
I think I see Alex has his hand up. Alex?
I previously suggested immediately preceding the application. So I think that it addresses the timing and recency issue, but I defer to anyone who may object to this language.
Or the minimum.
Immediately preceding the application.
Explore the minimum number of years of practice.
Susan?
I would object to immediate as far too specific in a general. If we are trying to make a general recommendation, I think recent is sufficient and we allow the court the proper deference to determine what that means.
Alex, your hand's still up? Okay, thank you about that. Okay, any thoughts on the language that we have here, or is someone comfortable enough that they'd like to make a motion?
I make a motion to approve.
Ryan makes the motion. Is there a second?
I second.
Judge seconds it. Any additional comments, dialogue? Friendly amendments, or are we at a point where people are comfortable with this and we should go ahead and take a roll call vote? Seeing no hands, Devin, let's go ahead and take a vote on this. Amy, I'd like to just vote on this and then we can move on to the foreign educated, if you don't mind.
Sure, no problem.
Thank you.
I'm sorry, can I just,
Yes, Karen.
should we say that requirements for licensed out-of-state attorneys? Like, I just still think we need to be really clear.
That would be a friendly amendment at this point to Ryan.
Yeah, I'm sorry, I
Okay.
reading it over.
Yeah, I don't have an issue with that.
Okay.
Accepted.
Thank you, Judge.
Sorry.
Nope, appreciate it. Okay, we have a motion on the table. Devin, let's go ahead and take a roll.
Susan Bakshian,
Yes.
David Boyd, Alex Chan,
Yes.
Charles Dugan, Jeremy Evans, Jackie Gardina, Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn, Tracy Montez,
Yes.
Judge Reeser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rossi,
Yes.
Emily Scavalletto,
No.
Karen Silverman,
Yes.
Mylan Spencer,
Yes.
Amy Williams. The motion passes.
Thank you, Devin. Amy, let's now turn to the subpart on this business item, which is the foreign attorneys and foreign educated applicants.
Mhm. All right, so here, the consideration were similar for foreign attorneys, and that is to allow foreign attorneys to also be admitted to California without sitting for a bar exam. And so the recommendation here is not to change those admission requirements. And this is on the basis of the data that we have on bar exam performance. So the recommendation here is that there be no change to the admissions requirements for foreign attorneys or foreign educated applicants. And so that would require that both sit for the 2-day exam.
Let me just ask the question, and maybe we can, there doesn't need to be conversation about it. Is there anybody that believes that we should be considering a similar result for foreign educated applicants as to out-of-state attorneys? Judge?
Well, not as to necessarily as to law school graduates or the equivalent, but as to practicing lawyers in a common law jurisdiction. It doesn't need to be the same requirements per se, but if someone has been practicing in a generally accepted common law jurisdiction for a number of years, it doesn't have to be 5, it could be 10, you know, should they be required? I think the Supreme Court should look at that as well.
Well, in an effort to draw out some conversation, I'm going to flip that question and ask if there's anybody that doesn't believe that I mean, it seems to me that I'm trying to find, after the judge earlier gave us an example of a former partner at his firm that came into the California and practicing. Is there any reason why we shouldn't have the same language that we're using for out-of-state attorneys for foreign practicing attorneys? Emily?
I think my concern, because I've had this discussion in the past, because I agree, it seems like, why are we doing this? But I do think it's hard to distinguish between which, I mean, you can say common law jurisdiction, but there are some countries where just having to have a fine line on which countries we are going to say are fine to come in and which are not can get really problematic. And we're really, I think at this point, talking about, you know, more than just sort of common law. Like there's also just the general practice of how we practice law in California. And especially if we are going to go to a more skills-based exam, I would not say that every common law jurisdiction is going to understand or have the same type of negotiation skills or you know, writing skills, etc. That and I don't even mean good or bad, I just mean different styles, and having to learn that and make sure that one at least has there is some sort of minimum competence showing before that they are allowed to practice here, I think is important. I don't know if that is our new bar exam, and if it has to be 2 days, maybe it could be less than that, but I really would worry about people not having practiced in the United States at all.
Judge?
So let's talk about that, because it presents some interesting, you know, questions. So my assumption is, since we passed the last proposal, right, almost unanimously, would we not want to have the same rule for Canada? The answer, I'm assuming, is probably yes, right? And so what Emily says is, well, maybe the same rule shouldn't apply to Malawi, which is, you know, former British colony, which would have common law rules. And I get it, there's some dicey questions there, right? And so do we throw the baby out with the bathwater, or do we try to figure out, you know, as Emily suggests, you know, is there going to be some remnant of an attorney exam that would formally be given to an out-of-state lawyer that we could revive for foreign attorneys? I don't know the answer to that question, but I'm still not comfortable about saying every country other than the US is, you know, we don't want to mix and match, so we ought not make the effort.
Amy, can you share the possible resolutions that you had in your staff report
Sure.
with regard to foreign?
Yes. So it's here the out of country attorney applicants can be admitted to practice law in California based on the minimum number of years of practice. And again, the commission determining years of practice and how whether those years need to be recent. This is just aligning with the previous recommendations for out-of-state attorneys.
So it would, so really the choice in front of us, and we can parse a little bit in where the judge and Emily were talking about, are we comfortable with something very similar to what we've just agreed upon for out-of-state attorneys? Or I think if you scroll down, you have a somewhere in there, you have the status quo resolution.
Here we go. The out-of-country attorneys, applicants that have established that they meet the eligibility criteria are eligible for licensure in California if they sit and pass the newly formulated California bar exam.
Yeah, and I think we're really focused on the foreign educated and out-of-country attorney. That's it. Yeah, right there. So I mean, that would be that would be the status quo. And so I guess the question is, you know, are we comfortable with sticking with that status quo? Are we comfortable with something close to what we had? And how do we manage through if we need to? Emily's concern that, you know, not all foreign jurisdictions are the same. Anybody have any thoughts on that? Okay. Does anybody want to make a motion on one or the other? Emily?
I think it's on the other page, but I moved for the status quo for
Okay.
foreign applicants and foreign educated applicants, or foreign attorneys and foreign educated applicants.
Amy, you want to pull the motion back up?
Yes, I will.
Okay. Does anybody want to second Emily's motion? Any more conversation? Kristen?
Thanks, Josh. I just, I want to add, I mean, I think for me, it's different than the out-of-state attorneys. You know, I am the president of an International Judges Association, and so I have very close friends, colleagues who are judges in Canada, in the UK, and they are more than competent, and they are, you know, brilliant, and they know the law in their country. But I can't get past the disparity between the bar passage rate for foreign attorneys and foreign educated applicants versus the out of state. And it's so big that I think that we can't really ignore that and say we should allow that same sort of minimum number of years that we all voted on a minute ago, because I think it is different. And it's not that they're not competent in their own countries, but that the law is really different. And I think it shows that in the bar passage rate. So, I mean, for me, I think I'm more comfortable with no change in the status quo.
Am I to interpret your comments as a second to the motion?
Sure, I'll second Emily's motion as well.
Fair enough.
You may, thank you.
Yep, thank you. Judge?
So my concern is utilizing what has been, I think, agreed are cultural biases in the historical bar exam as a means to, you know, exclude people who would be directly impacted by those cultural biases. So I mean, if we want to defer this particular issue to seeing the actual revised California bar itself. I think that's legit. But by saying, yeah, we want the Supreme Court to, make every foreign applicant take the bar exam, might be selling ourselves a little short.
Judge, do you have any specific language to this motion that you think would accomplish that deferral you're referring to?
So if you go to the first sentence, Supreme Court defer the requirements, modifying the requirements for licensed foreign attorneys to be admitted to California until what's the right verb of the new California bar exam, right? The revisions. And then we can leave out the second sentence, right?
Admissions requirements for foreign attorneys.
I want to be careful here, Amy, not to lose your motion. I mean, this is for people to see and think about, but I don't have a second on it, so please be careful.
Okay. Let me just say this one more time. And we're in your suggested motion modification, Judge, is for both foreign attorneys and for foreign educated applicants.
No, I'm only been referring to the licensed, competent lawyers, right? Because that's the concern I have. If somebody goes to a law school in a different country, that's a whole different question. Who has no experience, they have to be, satisfy the levels of minimum competence that we require for everybody else.
Emily, why don't we take your comments and then we'll talk about whether a friendly amendment would be considered.
Well, oh, go ahead.
No, go ahead, Emily.
All right, go ahead.
My comment just relates to, can the judge and I get together on this, right? So if we are, because I am perfectly happy, saying let's defer this question on both counts, both foreign attorneys and foreign educated applicants, until after such time as the new California bar exam has been implemented. But I would want that to apply, I think, to foreign educated applicants too, because if we can put that in as to, and maybe we don't need to, maybe that's okay, but I'm fine with that. I am concerned about the attorney from, I don't know what, Canada, let's use Canada, that comes to, that goes and gets a common law first degree in law and then practices for a little bit in Canada and then is able to come to California. That's possible. That's less experience than we're requiring for our 4-year minimum of out of state. So like those types of things is, again, it's why I voted no on the last one. I think there needs to be more, I'm worried about a shorter number of practice years. But on this one, if we want to say like, we can, just recommend that we defer this decision, that's fine. Actually, I'll just leave it there. So I'm fine. If the judge is fine with that, I'm fine with that as a friendly amendment, as long as Kristen's fine with it. The other judge.
Yes. Kristen?
I am fine with that as well.
Okay, thoughts on the motion that's in front of us? Other comments, thoughts? Dr. Henderson?
I guess we don't know what causes the difference in pass rates between for foreign applicants. There is a substantial difference. There are many reasons for that. The most compelling of which, to me, would be difference in their understanding of the Constitution and the law as it's practiced in California. I am not. I don't really understand the reason that we would modify the admissions requirements or recommend modifying the admissions requirements because of the possibility that the new exam would remedy that. It'd be really hard to demonstrate that it's fairer to this group given the small number of applicants that come through either of these routes. So I'm just not sure that I understand the benefit of deferring this recommendation.
I can speak to that if that's helpful, or.
Yeah, go ahead, please.
So I have worked with a lot and tutored a lot of foreign attorneys and foreign educated applicants. The number one reason they don't pass is because the California bar exam is not something, the number one reason they don't pass on the first try is that the bar exam is not something that they have lived and breathed for 3 years in law school the way our other students have. It is a very, very difficult exam for somebody to pick up and try to do that hasn't had all of these classes, to try to do that in 8 weeks. What I think we're moving towards in the new California bar exam is not necessarily that it's going to be any quote unquote easier, but it is going to be more related to the practice of law that they may have already had experience with as a foreign attorney, as a foreign educated applicant. And so by knowing what that California bar exam is going to look like later, we can then say, for foreign educated or foreign attorneys, should this be 1 day? Should this be 2 days? Should this be not at all? And hopefully have some empirical basis for that, because I don't think we necessarily do now as far as those rules. So that would be my response to that as to why wait.
Emily, let me just add that, we established earlier this commission, which subject areas as well as skills should be reflected based on the CAPA study, should be reflected in the new California bar exam. And I think by that expansion of the skills, I think speaks to what some of these attorneys and foreign educated applicants can successfully perform at. That's not included in the exam right now.
Jeremy.
Hey, Josh, thanks. Sorry for the background noise. I wonder, we saw a lot of presentations from other groups when it came to, the non-exam pathway or alternative pathway and other sort of aspects to this commission. Would it be wise to maybe have somebody come in to talk about the current application process? Matter of fact, I just met with the UK Minister of Justice this morning, and with him and a few other of the contingent here in Miami for the conference. And one of the things that they brought up was that they have a PowerPoint prepared in terms of, the foreign application process. I just wonder if that might be helpful to this group in terms of learning about it before we make a vote. My 2 cents. Thanks, Josh.
Yep. Amy, we have your the screen's off. We have your hard drive. There we go. Thank you. Okay, I think that, and look, I just want to confirm because we had a little bit of conversation here. I think we have a motion on the table from Emily, if I'm correct, and I think we had a second from Kristen. Is that accurate?
Yes.
Kristen?
Yes,
Thank
that is
you.
accurate.
Thank you. Okay. Any other thoughts, comments, or should we go ahead and take a vote on this? Judge.
So we're not voting for what's on the screen, right? We're voting for the status quo, Auntie.
Nope, we're voting for what's on the screen, I believe. This was a
Okay, got
friendly
it.
amendment that you made, that Emily accepted and Kristen seconded.
Okay, I missed that part.
Okay, that was my understanding.
My understanding as well.
Okay, thank you. Let's go ahead and take a vote. Devin?
Susan Bakshian,
Yes.
David Boyd, Alex Chan,
Yes.
Charles Dugan, Jeremy Evans,
No.
Jackie Gardina, Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn,
Yes.
Tracy Montez, Judge
Yes.
Reeser. Oh, excuse me. A yes for Tracy. Judge Reeser,
Yes.
Natalie Rodriguez, Kristen Rossi,
Yes.
Emily Scavalletto,
Yes.
Karen Silverman,
Yes.
Mylan Spencer,
Yes.
Amy Williams. And back to Natalie Rodriguez.
Yes.
Thank you. The motion passes.
Great, thank you. Amy, my understanding is that will conclude item 2A in business.
Correct.
Okay, great. So we took a break at in the middle of the time that I wasn't expecting in order to get that motion. We have about an hour and 15 more. I would like to just take at least a 10-minute break here so folks can use the restroom and get a snack. So let's go ahead and take a 10-minute break. We can come back and I think we can work our way through the next two business items. Thank you. All right, Devin, are you there?
I am.
Okay, great. Let's go ahead and a couple people join us and we'll get started again. Okay. I think we have 1 hour and I think we can cover both these topics in that time frame. Let me first turn to business item 2B. Discussion and recommendation for California non-exam pathway to licensure framework. We have, as everybody knows, discussed this and dialogued on this for many hours, unable to come to a consensus over our last couple of meetings. The intent on this business schedule today is not to continue to discuss it, but to explain what's going to happen from here. And then the deliberations we've had up until now, they will be summarized in the report that will come to us in draft form in January. We'll have an opportunity at that time to review it, comment on it before it goes out for public comment. It'll go out for public comment, it'll return to us, and we'll have an opportunity to address those public comments and frankly to retake up any issues that folks want to. There is not a necessity to have a conversation on this topic today, but nevertheless, as time goes by, sometimes people have thoughts, and I did want the opportunity to open it up. If someone had specific thoughts that they wanted to share from the last meeting, this is the time we can do that. If not, we can move on to business item 2C, until which time we have the staff report in our January meeting. With that, I will kick it off to Susan.
Thanks, Josh. I just wanted to make the comment today that I found the Legal Services Foundation's public comments today incredibly insightful and not personal. I don't think it's a personal attack to fact check a public comment letter by the CLA. And as a member of the Alternative Pathway Subcommittee, I agree that the CLA letter did misrepresent the Commission's work. So I just want to say thank you, and I appreciate the Legal Services Foundation and all of their efforts to correct the inaccuracies and move the public discourse forward on this topic.
Judge?
So to some degree, I want to echo what Susan just said because it's accurate. And I am respectful of, I think it was a 9-8 vote on the experiential pathway. But public comment, isn't just perfunctory. And I was listening very carefully and putting aside, because to a judge, right, attacks on lawyers is just kind of ambient background and you ignore it. But what I heard was that someone or a group of people with experience, at least in the provisional licensure program, were recommending a type of pilot program involving an experiential pathway exclusively limited to the public interest sector. And that's not something which we put forth as a proposal previously, but that's what I was hearing. And so perhaps, when we do report to the Supreme Court on it, we could conceivably float that as something coming out of what I consider legitimate public comment.
Well, I think the public comment is, and I don't think you meant it by this term, but I definitely don't take it as perfunctory. I think it was, it's always very useful. And I do think when we go out for a larger public comment on our committee report, that I expect we will get more detailed responses around that program and the thoughtfulness. And hopefully at that time we can engage in a larger conversation around it.
Thank you.
Emily?
I just had a question, and I think I asked this months ago and I don't remember, but is there anything that this commission can or should or needs to do as it relates to PLL recommendations? No. Okay.
No, I mean, PLL is, and recommendations is not within our scope. And I could, maybe this is a time that Donna or Leah can address it for you, but I believe that that's something that's being worked on outside of this committee, but or commission, but specific to the bar at this point.
Go ahead, Leah.
Yeah, I would just say that staff is going to be presenting recommendations to the Board of Trustees at its November meeting in about 2 weeks with respect to the future of the PLL program. So that's happening sort of on a concurrent but separate track from this process, and the PLL issue itself is not reflected in the charge for this commission.
Thank you.
Any other specific thoughts or comments on this item, or we will move on to 2C until our next conversation in January? Okay, so in an attempt to finalize a report in draft form, at least for us to discuss, I'm going to move to 2C, which is finalization of recommendations related to an exam pathway. Amy, what items do we need to discuss here that will help the staff in drafting that report?
Josh, this is a motion that was made early on after we made the recommendations, after this group made the recommendations on the scope of the exam, that is the subject areas and the skills. So I want to bring this motion back to the group because I think we didn't act on it, but it was proposed. And so this is about the manner in which the design aspect happens for the exam. So this is the motion specifically. If the Supreme Court adopts the Blue Ribbon Commission's recommendation to develop a California specific exam, the State Bar of California, in consultation with subject matter experts in exam development and other specialists, shall be tasked to design an exam for recommendation to the Supreme Court. The design shall be consistent with the guiding principles adopted by the Blue Ribbon Commission, including crafting an exam that is fair, equitable, and minimizes disparate performance impacts based on race, gender, ethnicity, and other immutable characteristics. So I'm bringing it back to the group to solicit feedback or recommendations and to just assess whether this is something that also should be included in the report.
So it's
Judge?
almost some housekeeping. We had the April 6th motions about developing a California specific exam, but we need something to talk about the design.
Audrey, just before we go to the judge, I'm trying my best on recollection. I mean, I'm fully aware of the motions that we passed at the time, but I don't remember. Was this considered?
No, so since April 6th, and I know there's a lot that's happened since then. As staff, we were thinking we need another motion to get us to the design of the exam and to work with subject matter experts. So it's like a if this then this. So if the Supreme Court adopts this recommendation to develop a California specific exam, we also need a motion about designing the exam.
Okay, thoughts, Judge?
So I would add disability to the last line there before the other immutable characteristics.
Okay.
Natalie?
Would it be possible to just bring back up the motions language so that we're being consistent?
It's hyperlinked there, Amy.
Sorry, give me 1 second. Okay, so here are the motions. Are they up? This is from the April 6th meeting.
Okay, thank you.
Sure.
Okay, other thoughts on the concept and specific language of this additional motion that staff is recommending we consider? I'm struggling in the first sentence a little bit, Amy, and I'm not sure I'm understanding completely. There's two references to the Supreme Court. There's a reference in the beginning on the if then, and then there's a reference at the end. Are there two recommendations going to the Supreme Court?
So if they adopt the state court in consultation or recommend shall be tasked to design an example recommendation to the Supreme Court. Yeah, so maybe this is redundant here. So shall be tasked to design an example.
Is it not just should be tasked to design an exam?
It shall be tasked to design an exam. I think the point here was that okay, see that. Consultation with subject matter experts and exam development shall be tasked to design an exam. Okay.
Emily.
I don't know the relationship as well as others between the Supreme Court and the state bar, but would the Supreme Court want another jurisdiction to create the exam? Are we basically recommending that the state bar be the person that, or be the entity that works with the experts to create it? And I'm fine with that. I just wanted to make sure that's what we're saying.
Yes, that's what we're saying.
Ryan, I'm going to take Neil out of order for 1 second.
Yeah, I was just going to say, I thought that the original language there about a design exam, a redesign exam would be ultimately recommended to the Supreme Court. Because if the exam format is changed, the court has to still approve it. So it would still come here as a recommendation. I'm just sort of clarifying the issue. I'm not saying it necessarily needs to be baked into this motion, but just trying to clarify.
I guess the question I was asking, Neil, I do appreciate that and saw that. I was trying to figure out if that would be a different recommendation, not by this commission. That was a confusing part for me.
I see, yeah. I would think it would be the subject matter experts, right, in combination with the state bar admissions folks and CVE.
Do you think that we should either reinsert that language or add additional language that would be more clear?
You know, I don't think that there's an actual rule of court that says that this court has to adopt changes to the format of the exam. So
yeah,
it's just part of what's baked in already.
That's how I understood it too. Okay, Ryan.
Yes, I'm just a little confused actually, and I just need help understanding. So, I mean, let me explain where I'm coming from. So, when we first started this Blue Ribbon Commission, we received a lot of information, a lot of reports, CAP analysis, and essentially the conclusion that I took from that was there are a lot of people who are not passing the bar exam, and the California bar exam is difficult. And there's no real relationship to the difficulty of the California bar exam and how well somebody practices law or how ethical somebody practices law. And so for me, it just seemed natural to make the bar exam easier, right? However we do it, we can make it easier to address the issue that the bar exam is unnecessarily difficult for a lot of people. Where we put that bar, I thought was a question that we were going to help answer with our various meetings and discussions. Now it seems like we're punting that to the Supreme Court. And that's that disconnect that I have. So I'm hoping that you or someone else can fill me in.
I mean, someone else may want to address that more directly. I get a little uneasy when you use the word easier. I don't think that was our goal necessarily. I think at least that's not how I saw it. And I think that the vision that we had was that we did want to connect the exam specific to the practice. I think we all agreed to that. And I think that was kind of the underlying reasoning for the motions that we passed before, that they had to be specific to Kappa, and we wanted to change the way the test worked. I think what's happening here is at some point we aren't the specialists in designing exam. I think Dr. Henderson's going to address that in a second. And so I think the idea was, how do we give some parameters? How do we give a little bit of guidance? How do we give some guidelines? How do we voice the need for change? But it's going to be some hard work. And we talked about that for quite a while. It's going to be a few years in development before we can get there. And I think what the staff is trying to do here is just give us that linchpin to the development side. We've made the statement, but how do we say, now you need to go do it?
Okay.
But again, maybe someone else can address that more clearly. Dr. Henderson?
Thank you. Normally, the matter of determining the design project would focus on Kappa and the outline that has been recommended, assuming the court adopts it, and then specifies item types and or types of questions and problems, and the way that the different topic areas could be integrated into the test, into the assessment. Once the test has been developed and the items written and validated and approved, then the difficulty level required that corresponds to minimum proficiency that would be required for passing the test would be determined through a standard setting study. And generally speaking, I mean, there are a lot of good methods for that. For a licensure test like this, it would have to be criterion referenced. But generally speaking, a panel of people the panel is diverse along the key dimensions of the profession. They would come together, they would review the actual examination, and they would follow the established method, the established method being undergirded through psychometric research, to make a recommendation on what the passing standard would be. Ultimately, the entity that sets the standard would receive that recommendation along with what's called consequence data. And that would be the impact of that standard on pass rate and potentially other aspects of performance on the test. Could be broken out by the various factors that might influence performance, the immutable characteristics shown here, but also the accreditation status of the law schools that they've graduated from. So the matter of determining how easy the test is kind of the last phase before it goes in.
Okay.
I hope that was helpful.
It was, and we're definitely not positioned to answer all those questions as this commission is established, and for the duration it will be established. Yeah.
Correct.
Okay.
Correct.
Dr. Henderson, can you talk for a moment about, and I think you've addressed it before, about the timing? I mean, obviously we had the earlier motion from, I think it was April, that we just had on the screen, and now we have this potential motion about it designing the exam. What would be the time frame if the Supreme Court were to accept our recommendations and to pull together the exam development and specialists? How long would it take to design an exam like this?
That's a really challenging question, and Tracy might want to weigh in on it as well. For me, the biggest drivers for time consideration would be whether the item types require any kind of research during their development. For instance, if the group that is designing it comes up with a new item type that hasn't been explored in psychometric research, then there would need to be some field testing of that item type before a recommendation could really be justified for its use. Barring anything like that, I don't think it should really take a terribly long time. I would think, I mean, again, a really diverse group looking at item types and the research about their impact on disability. And I mean, one of the challenges in anybody's test is the accommodation of disabilities and creating a level playing field for that group, along with all of the other special classes that are listed here. So, you know, pulling together the research could be done fairly quickly. I think it could be, you know, a matter of a few months.
Okay, Mylin?
Would it be all right? I wanted to say something in response to Ryan's question / comment. I don't know if that's appropriate at this
It
time.
is, yes, thank you.
Okay, so the point, as I heard it from you, Ryan, and I'll just speak directly to you, was that you understood the project to be primarily to make the California bar exam is too hard and we need to make it less so. I have been envisioning the project at its most simple level as the fundamental problem with the California bar exam is that it's invalid in the way that Dr. Henderson and other folks have explained again and again, that it doesn't test for minimum competence to practice law. It's not a question of how hard it is, because if it were how hard it is, we would just be lowering the cut score again, right?
Right, right, yeah, no, so
measures.
Yeah, to clarify, I viewed making that alignment more aligned, I guess, because it's not aligned at all, really. The natural consequence of that would be this was my takeaway. The natural consequence of that would be that the bar exam would be a lot easier.
And I guess I don't see that, and I don't want to get super philosophical at this time because I know we're supposed to be voting on this motion, but it does relate somewhat to my ability to vote comfortably for this motion. It needs to be more aligned, but for example, and this is something that I brought up in the past, there are, I believe, people who can pass the bar exam with flying colors who are incompetent at client interviewing. And that's a huge problem that I have observed first and second hand among California attorneys. So for me, it's the misalignment that's the fundamental problem. And we need to start testing for competencies that are required. And that's what CAPA was all about and all of that. So I'm a big believer in all of that. And to sort of bring it back to this motion, I'm having a little bit, let me say one other thing. The reason that I'm kind of taking up airtime on this is I know I would like us all to have that alignment or validity or that concern in mind when we consider the whole mission of the commission, because if there's any, I guess, and again, to you, Ryan, I know that you're one of the folks who didn't want to explore a non-exam pathway, but I was on that subcommittee and I feel strongly about the non-exam pathway. And let's make sure we know what we're giving up on when we give up on that non-exam pathway. That was, to me, the best way to ensure alignment. And I'm going to get down off my soapbox now, but just to kind of be concrete about it, I'm having a little bit of trouble putting all of the pieces together, as Natalie was asking, like to have the actual fundamental recommendation up there with the guiding principles would help me to better read this proposed additional motion. Sorry for taking up so much time. Thanks.
Okay, so I'll pull up the guiding principles, but I think what this is attempting to do, though, is to it's about the methodology, the method in which we're going to implement the previous recommendations that we highlighted. So the skills and the subjects that to be tested in the new exam. But I think more importantly, it's trying not to lose sight of the guiding principles that we've talked about here. So some of the things that were raised here, aside from like the item type, for example, in that discussion, we talked about how multiple choice could be one of these heavy memorization question types. And so looking at something that is more realistic, whether that is creating a vignette or performance test styled questions. Also, we talked about, ensuring that we're using universal language that is, more universally understood. So I think that this motion is attempting to ensure that we don't lose sight of that as this is being crafted. So it's about the methodology, but I just want to add that while I look for this other piece. So give me a second.
Dr. Henderson? Dr. Henderson, I think you're muted.
Sorry about that. Something popped up and hid the button. I don't recall I know that when we did the CAPA study, the group developed a construct statement that was a short couple of sentences at the most that defined what it was important to measure in the bar exam. And I'm not sure where that is in the approval process, whether by approving CAPA that, when assuming CAPA has been approved, whether that was considered and is now part of it. But back to the motion that's before us, I would suggest that we add a reference to a construct statement that and maybe the one that the group drafted. Somebody who knows more about the standing of that recommendation from the CAPA panel, not from the panel, from the group, the work group that supervised CAPA, that it strikes me as a very logical foundational starting point along with the guiding principles that this group has set up.
Yeah, I'm getting a little concerned that we aren't understanding the specific motion in front of us. So I believe in one of the problems here, Amy. I don't know if we can put them together. I think it was asked originally. There is a base for this. We passed it in April. It's a motion specific. I think this is a follow-on motion, and for us to reach back out and try to create a new base or add a new mission or guiding principles. This is already part of this commission's record. I'm struggling with kind of the relevance of bringing this into the current motion that's in front of us. Amy, can you just do this? Look at Donna had her hand up. Is it possible to just revisit for a moment? I know it's hard with two screens, the motion again that we passed in April, because that is what we are supplementing. is that original motion that now I believe staff is saying they need some action that's going to follow it. Donna,
Sure.
did you have a comment?
Just that the additional motion, as you're describing it, that Amy just had on the screen before, references the guiding principles that this commission adopted, which in developing those guiding principles, one of the components that we looked at was the construct statement that Professor Henderson is talking about. And so that was a building block, an essential building block for the principles already. And then I would just echo, Josh, what you're saying, which is this group has adopted the recommendation to the court that an exam be developed that addresses defined subject matter, and that's the motion that Amy's pointing to now, as well as addressing defined skills and abilities, all derived from CAPA. The recommendation now is just how do we get from here to there, right? This group is recommending to the court the exam should be built in a way that's testing this knowledge, skills, and abilities. And so now it's just a matter of giving, because this would be the handoff from this group, right? The group will make the recommendation to the court, and then the court will say, yes, go forth and design an exam based on this, and do so in consultation with relevant experts, making sure you're keeping all the guiding principles in mind, and then bring that back to us, the Supreme Court. So this really is the handoff from this group to turn this into ultimately what the exam would look like.
Yeah, as I see it, this is the content, and that's the mechanism, procedural mechanism. Okay, Amy, can you put back up the motion for a moment, Emily?
Oh, sure. I was just gonna move to adopt the motion that is before us, that is no longer before us, but
it's going to be again.
There it is.
And there it is. Okay, is there a second?
I'll second.
Thank you, Susan. Okay, are there specific issues with the language anybody wants to address? I think we've talked about the purpose for it. Jeremy?
Yeah, thanks, Josh. I was going to ask just really quick, and I don't know if Neil can answer this question directly or if he wants to, but whether this is needed or is this good advice or good consent, or if this is not needed. I'd be curious what Neil's thoughts are.
Yeah, Neil, if you want to address it, go ahead, please.
Well, it certainly doesn't hurt things. So I don't see any reason for this resolution to not be unnecessary or to not move forward.
Well, thanks, man.
Thank you. Okay. I don't see any other comments this time. Devin, why don't we go ahead and take roll?
Susan Bakshian,
Yes.
David Boyd, Alex Chan,
Yes.
Charles Dugan, Jeremy Evans,
Yes.
Jackie Gardina, Ryan Harrison,
Yes.
Dr. Henderson,
Yes.
Esther Lynn,
Yes.
Tracy Montez, Judge Reeser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rossi,
Yes.
Emily Scavalletto,
yes.
Karen Silverman,
Yes.
Mylan Spencer,
Yes.
Amy Williams. The motion passes.
Great. Thank you, Devin. Okay, this concludes our business for this meeting. I will state again, please be on the lookout for notification about a January meeting. Staff will begin working on our report, and we will get it in draft form, consider it, and make a determination whether to put out for public comment at our next meeting. Thank you, everybody. See you in 2023.
Thank you.
Thank you, Josh.
Thanks, Josh.
Yeah.